Hey everyone, I'm Mike Dahl. I'm a lawyer here at Valent Legal. Today we're going to be talking about birth injuries and medical malpractice and the things that you need to do in order to protect a loved one who may have suffered a birth injury. The joy of welcoming a newborn can often turn traumatic in the event that that newborn may have suffered birth injuries during labor or during the delivery process. Sometimes those injuries are unavoidable, but all too often they are the consequence of medical treatment that was substandard. A doctor or a nurse did something or didn't do something which could have prevented that injury in the first place. Knowing this and knowing when to file a birth injury claim can help ensure that you or your loved ones are provided with the lifetime supports that are needed to help ensure that that newborn or that child's life is as fulfilled as possible. For even more information about birth injury claims, check out our website at www.valentlegal.ca, and you can follow us on Instagram. Also, feel free to leave me any questions in the comments down below, and I'll do my best to get to them in future videos. A birth injury, basically speaking, is an injury that results during the labor or delivery process. And so it's an injury inflicted on a fetus, sort of in utero, or on a newborn. When we talk about birth injury in the context of medical malpractice, we talk about a birth injury that is preventable or was a consequence of an act, a substandard act. Common birth injuries include conditions like cerebral palsy, which is the result of brain damage during the birthing process, labor or delivery. Other common birth injuries include things like Erb's palsy or a brachial plexus injury, which is injury or damage to the nerves in the child's neck. Many of these injuries aren't diagnosable until the toddler phase. Cerebral palsy, for example, parents of a newborn whose APGAR scores or health immediately post-delivery raised red flags or increased the risk of a birth injury won't actually know whether that child has cerebral palsy until a few years later. It is often the case that there are suspicions of medical negligence and suspicions of a birth injury before that birth injury is actually known or realized to the parents or loved ones. There's something called an APGAR score, for example, which reveals the immediate health of a newborn in the minutes post-delivery. Where that APGAR score is low, that child is at risk of possibly severe future consequences. Parents of children who experience trauma during the labor process or who have low APGAR scores will be seen by medical professionals, or that child will be seen by medical professionals in the years that follow. That child's development will be monitored very closely. And it is the hope, of course, of every parent that those developments hit their milestones. Where they don't, that child has likely suffered a birth injury. And when that happens, it is parents of those children should go back and assess whether or not the doctors or nurses responsible for the labor, monitoring, and the birth, the delivery, met the standard of care applicable to their profession. Doctors, hospitals are required to keep patient charts for 10 years. In the case of a newborn, that 10-year clock doesn't start ticking until the newborn turns 19. And so it is always the case that the medical records required to be looked at, the medical records required to prove medical malpractice will exist even arguably decades after the birth. Lawyers like me who specialize in birth injury litigation are often approached by parents many, many years after the birth. Child is 6, 8, is not hitting milestones, has been diagnosed with cerebral palsy relatively recently, and you or they have concerns that maybe that cerebral palsy could have been prevented. You can have the merits of a possible medical malpractice case assessed through the help of an experienced lawyer working with a team of doctors, OBGYNs, for example. And that assessment can take place even though maybe we're talking about a birth that happened 10 years ago. And that's because medical records have to be kept for that length of time. So if you have concerns about, a loved one possibly having suffered a preventable birth injury, what you would want to do is reach out to an experienced birth injury lawyer with your concerns. That lawyer would help you access your child's historic records, right? Records related to the birth or records related to the labor process. Once those records are requested, experienced medical malpractice birth injury lawyers will work with doctors to have those records reviewed. One really important record that doctors and lawyers look at to determine whether there was possible medical negligence during a labor and delivery process is something called a fetal heart trace monitoring. That's a record of the infant's or the fetus's health in utero. And it dictates to doctors and nurses whether urgent steps have to be taken to deliver the baby, be it via C-section or forceps or what have you. And it can be the case that, for example, the fetal heart rate monitoring will reveal that an infant is in distress. And where medical professionals do not act in an urgent fashion, and then where that child goes on to suffer consequences, sometimes lifelong disabling consequences as a result of the medical professional's failure to act on signs that are revealed on the heart monitoring, then that medical professional or those medical professionals are liable for the lifetime of harms that child may unfortunately suffer. Just like any claim, there's a limitation period that applies to birth injury claims. That limitation period in Nova Scotia is dictated by something called the Limitation of Actions Act. And it says that someone who is injured as a result of another's wrong has 2 years to file a civil claim. Birth injuries are somewhat unique insofar as the person who has the claim is a child usually, right? An infant. And the law would not expect an infant to file medical malpractice lawsuits at the ripe age of 3 or 4. The law provides that limitation period does not start until the infant turns 19 years old. And so that's what gives the family a lot of time to assess, number one, the degree of the injury and whether a medical malpractice case may be a viable way of seeking supports for that child. Experienced medical malpractice lawyers with a track record of success will represent families in relation to birth injury claims on a contingency basis, meaning that it costs nothing to speak with a lawyer and to have that lawyer advance the child's interests legally. Fact of the matter is that advancing medical malpractice birth injury cases is time-consuming in terms of the legal work required, and also expensive in terms of the cost of the experts that are required to make the case successful. A typical birth injury case, for example, will need the medical opinion of a highly qualified OBGYN and the medical opinion of other specialists, neurologists, life care expectancy experts, life care planners, functional capacity occupational therapists, in order to prove the elements that are needed to be successful, both in terms of a breach of the standard of care causing an injury. Those experts are essential. You cannot advance a successful medical malpractice birth injury case without good expert evidence. Experienced medical malpractice lawyers will fund the experts needed to make the case successful, and they will also fund that on a contingency basis. And so at the end of the day, the family of a loved one who may have suffered a birth injury has nothing to lose by reaching out to an experienced birth injury lawyer and advancing the interests of that child who may, unfortunately, have lifelong consequences that could have been prevented. All right, everyone, those are some answers to frequently asked questions about birth injury claims. If you have any questions, feel free to reach out or leave a comment down below. I'd be happy to answer them in future videos. Also, you can visit valiantlegal.ca, follow us on Instagram, and we'll see you next time.